Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing what's referred to as solitary confinement in Canada. Solitary confinement is a form of incarceration where a prisoner is kept in an individual cell with no meaningful contact with other inmates. It's sometimes used for dangerous or disruptive inmates who are a safety risk to others, and it can also be used as a safety measure to protect inmates who may be threatened by other inmates, or as a form of additional disciplinary punishment. The use of solitary confinement is controversial, especially in Canada. The United Nations considers solitary confinement exceeding 15 days to be torture, but courts in Ontario and British Columbia have found that Canadian prisons systematically employ solitary confinement in a manner that may violate the Charter. The Trudeau government has vowed to end the use of solitary confinement altogether in federal penitentiaries and introduced legislation to replace the practice with something called structured intervention units. Where do things stand in Canada today? How does Canada compare to other countries? And what does the research tell us about the effects of solitary confinement? Here today to discuss this issue are two experts. Howard Sapers is a longtime prison watchdog and head of the Federal Advisory Panel implementing new structured intervention units. And Craig Haney is a social psychologist and professor at the University of California, Santa Cruz, noted for his study on prisons and prison isolation since the 1970s. Thank you both so much for joining me today. Mr. Sapers, I want to start with you. Can you explain to me or describe to me what does solitary confinement look like in Canada? How much time alone are we talking about? How much time outside? And what resources do inmates have access to, for example, books or televisions? What does it look like?
Sure. Okay. So first we have to get our language straight. So in Canada, we call solitary confinement segregation. And typically there's two kinds of segregation in Canada. Administrative segregation, which is exactly that. You can be placed in segregation for administrative reasons, not punitive reasons. And that's the other kind of segregation, which is disciplinary segregation, where if you're found responsible or guilty of breaking an institutional rule, your punishment can be isolation. And so segregation has always been considered like a place or a type of confinement. More recently, it's being considered by the conditions of that confinement. And those conditions are defined by lack of mobility and interaction with others, and no access, very limited access to the outside world. So mobility and access. So in provincial corrections, segregation still operates pretty much that way. You can be locked in your cell for 22, 23 hours a day by policy. In reality, often 24 hours a day. And that can go on indefinitely. And that's one of the problems, is that administrative segregation can be indefinite. It's not defined by a prescribed amount of time, like if you were sent to segregation for 5 days for punishment. In the federal system, in fact, the federal government did eliminate segregation. So in law in Canada, federally, in our federal penitentiaries where men and women are serving sentences of more than 2 years, there is no more such thing in law as segregation. It's now called structured intervention. And some people think it's just, new labels on old wine bottles. But structured intervention units were created largely in response to court findings that found that the federal use of segregation was in fact unconstitutional. And so these new SIUs have a different legislative framework. And so, for example, they say you can only be locked in your cell, and I say only in quotation marks, you can only be locked in your cell for 20 hours a day. The 4 hours that you're out, 2 of those hours have to involve meaningful human interaction. And we can have a conversation about what that actually means, what meaningful interaction has become. So that's sort of the lay of the land when it comes to the official kinds of segregation or isolation or solitary. But Christine, I want to just add that there's lots of other ways and lots of other reasons why prisoners will be confined to their cells. And so one of the things we have to think about is what are the other ways in which a prison system will isolate individuals. And I can tell you that there's a lot of what's called segregation light that goes on in Canadian corrections.
We've got to go to a commercial break, but when we come back, I want to get into that, and I want to pose some questions about how Canada's system differs from the United States, which perhaps Professor Haney can comment on. We'll be right back. Welcome back to Canadian Justice, where we're discussing what's commonly called solitary confinement in prisons. Professor Haney, I want to turn to you about maybe the American and international context of what solitary confinement looks like. Now, I'm sure there's quite a range, but how could you compare Canada's system, as described by Howard just in the last segment, to what happens in the United States? And is there a way to even generalize about what the solitary confinement experience looks like in American or international prisons?
Sure. Well, Canada and the United States are similar in the sense that both countries are in the process of very seriously reevaluating how they think about and how they use solitary confinement. I think it's fair to say both countries over the last 40 or 50 years began to use this as a mechanism or a device to try to control prisoners, oftentimes without much concern for its impact on the prisoners, how they were being psychologically damaged by the experience. But the last 50 years of research has underscored the extent to which people really are harmed by the experience of being placed in isolation. So both countries are now in the throes of trying to reconfigure what they do in order to both protect other prisoners, protect correctional officers, protect the inmates themselves who are at risk of being placed in solitary confinement, but to do it in a way that is more humane, that places time limits on how long somebody can be kept there. As Howard was saying earlier, what kinds of activities they have access to while they're there, to essentially try to distinguish the issue of separating people from the general prison population, from isolating people where they're deprived of meaningful human social contact, deprived of programming, and so on, none of which does much good in terms of maintaining order, maintaining safety, protecting the health and well-being of anybody in the prison system. And so we're trying to devise different ways of accomplishing well-justified, meaningful goals, but to do so in a way that doesn't harm people. So there's a lot of parallels in both countries.
Professor Haney, I want to follow up on what you just said about the psychological harm. Could you elaborate on what type of harms solitary confinement or isolation can have on prisoners, and maybe explain to our viewers why they should care about that? I mean, we're talking about sometimes people who have committed horrible crimes, and I want people to understand that even people who society has convicted and who have committed abhorrent acts should still be entitled to humane treatment. Maybe you could elaborate on that, on both of those points. What's the harm here, and why should people care?
Well, the harm is often devastating, and I think maybe your audience can reflect for a bit on the social isolation that we've all been through collectively in just the last year and a half. A much more modest form of isolation. Social isolation, we understand, itself can be a devastating psychological experience. And then if you add on to that all of the other deprivations and all of the other kind of oppressive forms of control that take place inside prisons, it can be a very harmful and even dangerous experience for people to go through. High levels of depression, high levels of anxiety, cognitive difficulties. The highest rates of suicide that occur in any prison system occur in its isolation units. Why should we care? Well, we should care because we're both countries humane societies. We have principles that obligate us to treat all of our citizens in humane ways. That's the first concern. There's even a more pragmatic concern, which is that if we damage people and we hurt them and we transform them in negative ways, the overwhelming majority of them are going to be released someday from prison. All of us, I think, would like to live with neighbors who have not been destroyed or damaged by the experience of imprisonment, so that they have a more difficult time reintegrating in a meaningful and contributing and productive way into the larger society. So there's a humanitarian set of concerns and there's a pragmatic or practical set of concerns, and I think they connect, or they should connect, to all of us.
Mr. Sapers, we've only got about 30 seconds in this segment. Anything you want to add to that?
Well, I think it's important to remember that people are sent to prison as their punishment, not for punishment. In other words, the courts have said you're guilty, you're going to go to jail, you have to be separated from society. That's the punishment. Once you're in prison, the goal is to prepare you for release so you can be functional and live legally and safely in the community. So all of our rules, all of our policy, all of our procedures are all geared towards achieving that end. And you can't do that if you lock somebody up and isolate them for people throughout their sentence. It's just totally incompatible.
We've got to go to commercial, but when we come back, I want to discuss who gets put into solitary confinement or isolation and why. We'll be right back. We're discussing what's commonly referred to as solitary confinement in prisons. Now, Mr. Sapers, I want to talk to you about solitary confinement and who gets it and what they get it for, and what the law says about why someone can be put into solitary confinement versus the actual reasons they might be put there. What can you tell me about that?
Well, sure. Both federally and provincially, the laws are similar. So you can be put into isolation. So in the federal system, in SIU, in the provincial system, into segregation. For your safety, for the safety of the institution, or to protect the integrity of the operations of the institution, or perhaps an investigation into an incident. So those are the legal reasons why you get put into these isolated conditions of confinement. What we find is that people who are behaviorally disordered, they're hard to get along with, they don't really listen very well, they're just strange, they annoy people, they provoke people. People who have medical issues. I've dealt with people who have been segregated because they're in wheelchairs. I've been in prisons.
What would the reason for that be? It's inconvenient for the guards?
Exactly. I've been in women's prisons where women who are pregnant get segregated. And as Professor Haney said, the issue may not be that you're kept in a separate kind of confinement. The issue is the isolation and the deprivation that gets added to that. Because once you're in a segregation unit, you're treated like a segregation unit. So you can have a unit with a number of cells, and one cell will have somebody who's on a suicide watch, one cell will have somebody who's medically infirm, and another cell could be somebody who's being punished for violating an institutional rule. But that whole unit is being operated to the same standard, the same security, the same levels of isolation. And that adds to the kinds of harms that Professor Haney was talking about, particularly if you don't know when you're getting out. And that was one of the issues. The other thing about segregation in Canada is that we see it differentially affects different populations. So overused for people with mental health issues, overused for people who are visibly from minority groups, overused for Indigenous men and women in prison. And so there are some discriminatory elements to the use of segregation in Canada as well.
Professor Haney, as we said, the federal government has this plan to phase out the use of isolation and have these structured integration units. What is happening internationally? Are there any countries that have phased it out? What does it look like there? And what does sort of international law say about the use of solitary confinement? I know in the opening I mentioned this definition of torture. Can you add anything to any of that?
Well, I think it's fair to say that internationally, at least with respect to the European Union, they approach this issue very differently. And many European Union nations that like Canada and the United States had come to rely on solitary confinement have either or are in the process now of, as our countries are, reducing their use and reducing their reliance on it. And some of the European countries have really never used it in a significant way. I do a lot of work in Norway, for example, and the Norwegians just don't use solitary confinement as a form of punitive isolation or segregation. They regard it as counterproductive. They have difficult prisoners. They have prisoners who have mental illness issues. Howard referred earlier to many people with behavioral health problems ending up in solitary confinement. That's a problem in the United States as well. People who are manifesting underlying psychiatric disorders, sometimes undetected, sometimes untreated, oftentimes find themselves in solitary confinement units. Many other countries, European countries particularly, recognize that issue and, in fact, treat those prisoners in a very different way. They provide them with treatment rather than isolating forms of punishment. I think in the United States, we're working our way through that problem. Like you have provincial jurisdictions, we have state systems. They operate differently from the federal system. They're a little bit difficult to get under control in a uniform way. But I think many states have seen the light on this issue. And in fact, state legislatures in the United States have passed laws limiting the amount of time that people can be kept in solitary confinement to more or less conform to the Mandela 15-day limit that you alluded to earlier. And then to provide something like Howard described Canada moving towards, units which separate prisoners, but provide them with programming in lieu of isolation.
We've got to go to commercial break, but I want to talk briefly about the difference between solitary and the health lockdowns that we've seen during the COVID pandemic. We'll be right back. I want to ask you both, I'll start with you, Howard, about how COVID-19 has changed what solitary confinement might look like in prisons. I know it's led to health lockdowns in a lot of prisons. It's been used to isolate prisoners for, in some cases, I think 23, 24 hours a day, just for health reasons. How does that compare to solitary confinement? Is it treated sort of the same way in law as solitary confinement, or is it treated differently?
It's treated very differently. One of the things about structured intervention units and segregation units in Canada is that they are governed by a legislative framework and a policy framework that requires at least some degree of monitoring, reporting, and oversight. Often inadequate, and the courts have been dealing with that. But at least some of that. When it comes to things like lockdowns for security reasons or medical reasons, a lot of those safeguards disappear. They simply don't exist. Lockdowns in jails and penitentiaries is nothing new. Lockdowns happen for a myriad of reasons. Sometimes they happen for the wrong reasons. And even with COVID, we've seen a real variation. Some systems in Canada preemptively lock down institutions and units as a means of stopping spread within an institution. Some only reacted to an outbreak. Some isolated prisoners, but didn't particularly address some of the public health measures for staff coming in and out of the institution. And so you've seen a variety of responses. Many prisoners, though, have reported that their access to programs, lawyers, health treatment has all been extremely curtailed during the COVID pandemic. And in some cases where there's not even an active outbreak in the institution. So there's just, as I say, this preemptive sort of interruption with normal routine. So many people have experienced the same kind of isolation and the same kind of deprivation without it being considered segregation or solitary confinement.
Same question to you, Professor Haney. I mean, if the consequence psychologically on the prisoners of a COVID lockdown is the same, how is it different, and should it be treated differently in law?
Well, it's certainly the topic of a great deal of focus and litigation in the United States. What Howard described happening in Canada happened on a widespread basis in the United States. Prisons, as a rule, are not very nimble institutions. And so when they're confronted with an unexpected crisis, they tend to fall back on a one-size-fits-all solution. And in many prisons in the United States, systems in the United States, they mistook medical isolation for disciplinary segregation and implemented the same kind of procedures with the same kind of negative consequences on the prisoners involved, except now there were vastly greater numbers of prisoners being exposed to damaging forms of isolation. And so in many instances in the United States, we've had to litigate over these issues to try to force jails and prisons in this country to be more responsive to the medical threat, the medical need, which was real, but not do so in a way which, in the name of protecting somebody's physical well-being, sacrifice their psychological well-being. And so that was the tension. And it's a tension, frankly, that's still being worked out in the US.
Yeah, it's certainly a really difficult balance to achieve. Mr. Stapers, just in the last 30 seconds, are you aware of any litigation in Canada related to the COVID
yes.
lockdowns?
Yeah. No, there's class action lawsuits around lockdowns, and there's matters before the courts currently, on an individual basis as well. And they engage a variety of charter sections, right to life and liberty, section 7, the section 12, section 15 issues to do with discrimination. Yeah, there's lots of litigation.
That's all the time we have. I want to thank you both for coming on and sharing your time and expertise.
Pleasure.
Thank you.
We've heard today about the use of solitary confinement in Canada and internationally, about how often it's used, why it's used, and the impacts it can have on prisoners. Few people may have sympathy for those who are incarcerated, but we have obligations, both as a government and society, to prevent treatment that rises to the level of torture, even to those people who society abhors. What will the future of incarceration look like? Can solitary confinement be phased out? What will the replacement system look like? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.